Welcome to the second annual Hamburger-Frankfurter Debate. We're very excited that all of you could be here to join us. This is a part of what we do with the Ginsburg-Scalia Fellowship here at NCLA, trying to promote a civil debate, and very excited about the two distinguished thinkers that we have here, and hopefully humorous thinkers. We'll find out to debate tonight's topic. Resolve: the Supreme Court should reconsider the test courts use to assess the permissibility of congressional delegations to federal agencies. So, look, we're just trying to figure out, should the court change its approach to the non-delegation doctrine or not? Arguing in favor of reconsideration will be Carter Phillips. Carter is a longtime partner and sometime head of the appellate practice and head of the DC office at Sidley Austin. He is one of the most experienced Supreme Court and appellate lawyers in the country. At last count, though with Carter it's hard to keep track, he had argued 90 cases before the U.S. Supreme Court and more than 150 times before the U.S. Courts of Appeals, including at least 2 arguments in every circuit and 40 cases before the United States Court of Appeals for the Federal Circuit. The justices have suggested an appellate easy pass system for Carter just to save time.
I've asked.
I made that part up. Arguing against reconsidering the current non-delegation doctrine will be Professor Mike Seidman, who served as a law clerk for J. Skelly Wright of the DC Circuit and U.S. Supreme Court Justice Thurgood Marshall. He joined the Georgetown Law Center faculty in 1976 and has visited at Harvard, the University of Chicago, NYU, and the University of Virginia. He literally wrote the book on the U.S. Constitution. Well, it's a case book. In fact, it's the case book that was used in my constitutional law class. But we won't hold you responsible.
Apologies.
Yeah, we won't hold you responsible for what I've done without learning, Professor Seidman. The debate will proceed in a format whereby Carter will have about 9 minutes to open, Mike will have about 12 minutes to respond, and then Carter will have about 3 minutes to rebut, and then we'll all go upstairs for some burgers, franks, beer, and more civil conversation. So with that, Carter, the floor is yours.
Thank you, Mark. I appreciate that. First of all, I appreciate being here and being invited. It's a pleasure. When I was sitting there a few minutes ago and I heard absolutely no noise here, it occurred to me maybe nobody was going to come watch us debate. And then suddenly I heard all this noise and I thought, oh, so the palm has been opened up. So anyway, I was a little taken aback by the idea of a debate because recent experience on big debates leads me to the conclusion that if you do a poor job, you could lose your job. So I take this much more seriously than I might have otherwise. My law firm does want me to be very clear that any views that I express here do not reflect the views of Sidley Austin LLP. Indeed, I think it's probably arguable that any views I express here may not actually reveal my own views about these specific issues, but we'll sort that out. On what is, to my mind at least, the fundamental question we have to address today, which is Burgers versus Frankfurter, I have to start off by telling you, I clerked for Chief Justice Burgers, so this is no serious debate. It's Burgers, it's not Frankfurter, so let's just be clear about that. So what we're really here to talk about is the dismantling of the administrative state. And should we do that, or maybe we don't need to? I mean, everybody's talking about Chevron, right? Chevron just got overruled and Loper-Bright. Chevron kind of came off your tongue a little bit. Loper-Bright is not, but fortunately, unlike Chevron, Loper-Bright doesn't have a 2-part test. It's probably not going to get cited nearly as frequently, since it's going to be, at least to some extent, just an opportunity for the courts of appeals to say what the law is, and the Supreme Court. I mean, the Supreme Court hasn't actually relied on Chevron for almost a decade, so it wasn't like that was a big shift in terms of how that played out. But if you read the press, you'd say, well, the administrative state's put to an end. What more do you have to do? And I guess I'm here to suggest that one more step, because if you read the Chief Justice's opinion, he keeps talking about delegations within the limits of the law, without actually saying what he means by what are the limits of the law. And if you go back to 1935, which I know you may doubt this, but is actually before my time, you go to Schechter, Poultry, which said that you have to be careful with these delegations, right? What are we talking about here? We're talking about grants of legislative authority, in theory, being given to other portions of the federal government, either the executive or in some instances potentially as opposed to the judiciary. And if you go back in time, and focusing on history shouldn't come as a huge shock to anybody who's looking at me, right? History in this country will benefit people who are old, white, and men. Also, it helps if you have property. So I'm way ahead on almost any historical analysis that the Constitution wants to propose. But if you do look at history, which I'm suggesting you should, you would look at a very small administrative state. You would see very narrow and limited delegations of authority that didn't feel like legislative delegations, right? They felt like efforts to allow the executive or the judiciary either to execute the laws or to perhaps properly perform their functions. Now, in absolute candor here, what I'm going to argue before you is stolen straight out of Justice Gorsuch's dissent in Gundy versus United States, where he laid out on behalf of two other justices with Alito saying, man, I might be persuaded if I had another vote, but I don't, so I'm not. So he didn't actually join that. But basically what Justice Gorsuch said in his opinion is that historically there are three very narrow limitations on when Congress can give its legislative authority or can act pursuant to its legislative authority in order to allow the executive branch to operate, or the judiciary, or the other two branches of government. The first one is just to fill in details, right? So the example he had was to delegate to the courts the ability to adopt the rules that the states were using for their procedures, and any other things you want to sort of throw in there. I mean, arguably, that's nothing more than an exercise of what you would think of as inherent judicial authority to make the rules on the basis of how you would decide particular cases. So that one seems pretty uncontroversial to me. The second one is that you would make a delegation contingent on the executive branch making a certain finding. Now, maybe it has to be an adjudicative finding, or maybe it has to be a legislative type finding. But the example again that he used there, which is an interesting one, is should we continue an embargo in place against France or England in the event that one or the other one of them stops interfering with our trade? And the suggestion was that if the executive found that one of them stopped interfering with our trade, then we should just embargo against the one that is interfering with our trade. And that seems like a pretty sensible delegation of an area that arguably is within the executive branch's expertise anyway, maybe even within its authority in operating foreign affairs, but that's not one that's particularly troublesome. And the last one is classically in the foreign policy area, sort of non-legislative acts that are just delegations of authority to do the work. I mean, a lot of the appropriations laws candidly fall into that particular category. So that was his view of the world. And then he said, look, 1940 came along with the Depression and the war and everything, and we ended up with all of these alphabet agencies. And Congress started to delegate to them extraordinarily broad authority in Schechter Poultry, which was the one that was struck down. It was just simply set the rules that will regulate how agricultural products are distributed within the United States. And so the administrator did that and enforced the law in a way that seemed candidly unfair, and the court struck that down as an unconstitutional delegation. But since that time, the court has pretty consistently declined to find that any delegation of authority is unconstitutional. And it's difficult for me to understand that when you're talking about terms like public interest and just and reasonable and those kinds of concepts, because it seems to me the essence of the legislative function is determining what the public policy of the nation should be and what rules should guide the conduct of private parties and the other branches of government in terms of how they operate. And to delegate to the agencies the determination of whether something is just, whether it involves the public interest or serves the public interest, is in effect saying we're going to allow you as to act as legislatures for these purposes, right? Without having to deal with any of the other kinds of issues. And the reason why you know that this has got to be at least somewhat of a concern, has been, is candidly the major questions component of the Chevron doctrine, right? When the court pulled back, right, and recognized that there's a difficulty here. if you say to the Environmental Protection Agency, go out and regulate for the public good, they can do just about anything they want, and in ways that could be quite harmful to a lot of interest. And not to say that that's a bad thing necessarily, depending on your overall point of view, but at bottom, it feels as though that's an issue that the legislature itself should decide, that Congress itself should decide, rather than leaving it up to the agency to make the fundamental decision. Once Congress decides what kind of pollution-free environment we should have, leaving it up to the agency to enforce that seems to me obviously the only sensible way to go, because the executive branch has the power to enforce those laws. And candidly, the court's Jarczy decision maybe even has helped in that respect, because it sort of shifted at least some of that decision-making out of the executive branch and into the judicial branch, which I think is probably what the framers really envisioned when they started in a simpler world, which was that legislation would be very clear and precise, that are more or less precise as the human language allows, that the executive would enforce it, and that the judiciary would tell you what the law is, and that the enforcement mechanisms would be handled mostly through the judicial process. I don't know that anybody envisioned the idea of administrative law judges back in 1789, 1791. So to me, the Constitution's been allowed to be manipulated over the last 60 years, or 70 years, I guess, in a way that's not what the Constitution envisioned. And if the court's in the business of trying to rejigger how the Constitution applies in the 21st century, the right answer is to start with the non-delegation doctrine and enforce it in a sensible manner. Thank you.
Okay, so I want to start by letting you in on a secret, maybe even oversharing. I am a little nervous about being here tonight. That is partially because of what Carter said about debate. So I just want to say, for starters, I am getting over a cold. A couple of weeks ago, I summoned up all my courage and went over the American Legion Bridge, so I'm really jet lagged. But unless the almighty Felix Frankfurter himself comes down and tells me I am not leaving this debate, all right? But there's also another reason I feel like I'm a little out of my league, frankly. So Carter is one of the leading Supreme Court advocates of our time. He's won countless cases before the Supreme Court. I've never appeared before the Supreme Court. I am a struggling, underpaid, underfed, and anonymous scholar who labels over obscure texts by candlelight in my unheated attic. The truth is, I can't even get my wife and my kids to read the boring books and articles that I write. So I've thought a little bit about how I'm going to boost my self-confidence here, and I've decided on what I'm going to say. So here goes. I want everybody in this room to know, in my entire career, I have never lost a case before the Supreme Court, and I don't think Carter can say that. All right. I'm feeling much better now, so let's get to the merits. I think there were actually two separate arguments against delegation to administrative agencies. Both of them, I think, are wrong, but they do need to be disentangled. So the first argument is an argument from democracy, and it goes something like this. A delegation of law gives authority to faceless bureaucrats. These bureaucrats are always described as faceless. I'm not quite sure. It would be pretty scary running into one without a face. Anyway, that's undemocratic.
That's because you don't litigate.
And it violates the Constitution's fundamental commitment to popular democracy. The people's representatives from Congress should decide basic questions of public policy, which should be open to public discussion and debate. The delegation of lawmaking authority to bureaucrats allows members of Congress to avoid tough choices, and so it undermines democratic self-rule. That's argument number one. The second argument I'm going to label the argument from free markets. It's sometimes confused with the first argument, but actually it's very different. The argument here is that delegation of legislative authority is the engine that powers the regulatory state, which ought to be dismantled. And by the regulatory state, I mean a government that actively pursues regulatory and redistributive goals by attempting to control market forces that would otherwise dictate economic and social outcomes. So what are we to make of these two arguments? Let's talk about the democracy argument first. And I want to start by saying that at the highest level of abstraction, I agree with it. So I do believe in popular self-rule and in public involvement in policy making. But translating those lofty ideals into an anti-delegation doctrine just doesn't work. So we can begin with a contradiction at the heart of the doctrine. It masquerades as an effort to retain the power of the people's representatives in Congress. But what it actually does is to limit the powers of Congress. After all, it is the people's representatives who have decided in the first place that it's good public policy to delegate legislative authority to administrative officials. And if the people don't like that outcome, and sometimes they don't, they can do something about it, and sometimes they do. They can elect new representatives. What the non-delegation doctrine actually does is it transfers power from Congress to the Supreme Court, which, using standards that are every bit as vague as anything Congress uses to delegate legislative authority, decides which delegations are allowed and which ones are not. And however undemocratic administrative agencies are, courts are worse. Justices aren't elected by anyone. They are appointed for life and deliberately shielded from popular control. Okay, but let's ignore that fundamental contradiction, and let's try to take the democracy argument really seriously. Remember now that to take it seriously means that the objection people have to delegation is not that they believe in free markets. That's a separate objection, which I'm going to get to in a minute. Not that they think the government shouldn't, say, provide for clean air, worker safety, or consumer protection. They're fine with all this. We're assuming arguendo. They just think Congress should make the hard decisions. So what would actually happen if Congress tried to make those decisions? Here's what would not happen. Individual members of Congress would not spend their entire day carefully studying the science about whether and how downwind pollutants from stationary sources affect air quality. They wouldn't become experts on the economics of same-day lending and conduct detailed empirical studies about whether the practice helps or hurts impecunious borrowers. Nor would they themselves conduct studies about which assembly line tasks produce carpal tunnel syndrome and whether those tasks could be performed in a safer way at a reasonable cost. Of course, members of Congress are not going to do that work for themselves. There's no way they could. So what would they do? If there is still going to be regulatory legislation, what they would do is to greatly increase the size of their staffs. They would have to hire hundreds, thousands of experts who actually know something about these things and have the time and expertise to deal with them in a sensible way. So right now, congressional staffs are way too small and way too underpaid. But to do this task, we aren't talking about a change at the margins. We're talking about a massive transformation of the size and responsibilities of the people who work for Congress. Put differently, what would have to happen is that Congress would have to recreate administrative agencies. But now, instead of being housed in various buildings around D.C., all of those agencies would be crammed into the Russell and Longworth Senate and House office buildings. Now, of course, that's not going to happen, but if it did, would it really make our system more democratic? I doubt it. These bureaucrats would be just as faceless and powerful as bureaucrats working for the executive branch. In fact, that would make the system worse. Executive bureaucrats are subject to the Administrative Procedure Act. They have to deal with notice and comment procedures. They have to put their reasoning on the record. They're subject to judicial review. Congressional bureaucrats would be subject to none of that. Yes, their bosses might lose elections if their constituents didn't like what they did, but as things stand now, their bosses can lose elections if they delegate more power than their constituents like. And of course, presidents can lose elections if people don't like what executive bureaucrats do. But let's be real. No one expects Congress to recreate the administrative state in the Russell and Longworth buildings. What would actually happen if Congress were forced to regulate with more specificity is that it would not regulate at all. Familiar legislative gridlock would set in, and so there would be less interference with market outcomes. And because that is the likely result of what advocates of anti-delegation favor, it's also likely that that's why they favor it. In other words, what's really at stake here is not the argument from democracy, but the argument from free markets. And by the way, that's certainly what was at stake in the 1930s when, for the only time in our history, the court tried to enforce the anti-delegation doctrine against Franklin Roosevelt's New Deal. The reactionary judges on the bench at that time were hardly robust defenders of popular democracy. They were robust defenders of what they thought of as free market capitalism, that they thought the New Deal threatened, and they used their power to try to protect the economic system they favored against huge popular majorities that supported Roosevelt and the New Deal. And I think that's what's at stake now. It's hardly a coincidence that most of the judges and academics who favor revising the anti-delegation doctrine are also conservatives, many of whom deny that there is global warming, don't like redistribution, and want to leave vulnerable consumers or factory workers to their fate. Now, if that's what's really at stake, and I think it is, that's what we ought to be debating. Unfortunately, though, that debate would be really complicated, and this gentleman's just told me I have less than 3 minutes to do it. So without trying to do that, I will just very briefly state what my position is about this. As a general matter, I'm more open to regulatory efforts to control private power than many conservatives. It's true government bureaucrats don't always act in the public interest, but if we don't like what they do, we have a democratic remedy. The fact of the matter is no one ever elected Elon Musk to anything, and there's no way we can vote him out of office, and he has the power to do tremendous damage. Of course, that doesn't mean government regulation is always good and free markets are always bad, but the very fact that the issue is complicated and context-specific suggests that turning the question over to judges applying constitutional law is the wrong way to deal with it. Ultimately, the extent to which the government regulates economic activity is a public policy question, and in a well-functioning republic, questions like that should be remitted to political institutions, not to an elite and unelected judiciary. And with that, I'm going to return to my unheated attic and turn things back over to Carter.
Thank you. That was well done. Let me start off by saying, if somebody comes up and tells you that I'm a poor, pitiful guy and I'm nervous and all that, watch your wallet. Things are going to turn out not well, as far as I'm concerned, and it's exactly what happened. That if there was nervousness from the professor, I certainly didn't evidence it in his presentation. The issue about democracy is kind of interesting because that is that's one way to characterize as a fundamental tenet of the non-delegation doctrine. But the reality is that the structure of the government was designed to protect liberty. That's the purpose of it. Now, it may be that it'll also protect property. I'm not going to give up that issue either. But the fundamental purpose is to protect liberty, which means it is supposed to be hard to pass legislation. It is supposed to require significant time and effort and energy to achieve it. You don't have to enforce those laws. You have an executive branch that will allow you to enforce those laws. But the fundamental questions of what's in the public interest and what rules should govern private action are decisions that Article 1 starts off by saying all legislative power is vested in Congress. And therefore, unless you're going to accept the idea, because if you accept the idea that some of it doesn't have to be in Congress, then where do you draw that line? Where is the limit to it? I mean, Gandhi, the case that triggered Justice Gorsuch's dissenting opinion is a case where they said, anybody who was a sex offender before a certain date can either be included or not as the Attorney General decides. I mean, how can that not be a delegation of fundamental decision-making involving, in this case, fundamental liberty of the individuals involved? And so the point is that if you eliminate the non-delegation doctrine, you end up in a situation where Congress candidly will continue to freely delegate and agencies will continue to work. And we can nip at the margins. We can insist on more judicial scrutiny. We can try to strip some of the agencies of what they have used historically in their internal decision making and the kind of extraordinary pressure that they can put on private individuals to comply with whatever the particular agency's view is. But as I think the right answer is we don't decide this on the basis of what is most convenient or easiest or simplest, but instead we decided on the basis of what the constitutional framers envisioned, then you'd have to say that the non-delegation doctrine ought to be reinvigorated and ought to be applied that way. And if you don't like that, there is another solution, which is amend the Constitution. And if democracy really works and should work, that's the solution to this particular problem. And on that note, I think we're ready for hamburgers and hot dogs.
Well, thank you very much to both of you. You're both expressed concern about potentially losing job as a result of losing a debate. But I'm reminded that the topic at last year's Hamburger-Frankfurter debate was whether or not Chevron should be overruled, and lo and behold, less than a year later it was. So let's keep that tradition going for a second year, and let's see the non-delegation doctrine restored a year from now. That's what I would like to see.
I'm so glad you're neutral about it. I can see I persuaded you.
I thought I was just really persuasive. He came in neutral.